This podcast covers constitutional law. The United States Constitution was signed on September 17, 1787, at the Constitutional Convention in Philadelphia. The purpose was to establish America's national government and guarantee certain basic rights for its citizens. Each state subsequently signed its own constitution. When the Constitution was signed, the U.S. population was only 4 million. It is now over 326 million. Also, at the time of the convention, Philadelphia was the most modern city in America and the largest city in North America. Its population was 40,000. Some interesting facts are that it had 33 churches, 10 newspapers, and 1 university. Over 200 years later, the United States population and economy have grown more than the framers likely could have ever imagined. Yet throughout these changes, the Constitution has endured and adapted. Constitutional law refers to the judicial interpretation or the court's interpretation of the United States and each of the states' constitutions when legal disputes arise. These disputes can arise in federal or state courts. Each state has its own court system and interprets its own constitution. All state constitutions must conform to the United States Constitution because that document is the supreme law of the land. For example, a state law that limits freedom of speech is contrary to the United States Constitution and is unconstitutional. Congress makes law. If a law is contrary to the U.S. Constitution, the U.S. Supreme Court can strike it down. This concept is known as judicial review. For example, Congress enacts a law that states that if you work for a federal government agency, you do not have the right to protest against that agency. A lawyer at the U.S. Attorney General's office protests against that agency and is fired. The attorney brings a lawsuit in federal court. The federal court strikes down the law because it is contrary to the freedom of speech granted in the U.S. Constitution. Executive actions can also be stricken down if they are contrary to the Constitution. How do courts interpret the Constitution? They try to rely on the plain meaning of the text. For example, with respect to the right to bear arms, the freedom of religion, right to vote, and freedom of speech, the courts try to rely on the plain meaning of these texts. What about the right to terminate pregnancy, for same-sex people to marry, and more? Well, the text of the Constitution is not clear on these issues. As we know from the news and legal disputes, these issues remain controversial. One case, Obergefell v. Hodges, the U.S. Supreme Court held that the fundamental right to marry is guaranteed to same-sex couples by the 14th Amendment to the U.S. Constitution. The doctrine of original intent. This doctrine asks what the framers of the Constitution intended. What would they have intended as to these now controversial issues? Could the framers have even foreseen them? The idea behind the doctrine that the Constitution is a living, breathing document. Here, the idea is that the Constitution is alive and changing along with our society. The idea is the original intent, even if knowable, should not control contemporary constitutional decision-making. The doctrine of original intent is not universally accepted. The reason is the intentions of the framers are impossible to discern. The living Constitution, the idea that the constitutional principles apply to what are considered felt necessities of current times. Precedent. How do courts decide cases? They look at the law. They look to past cases. Courts rely on what other courts have said and done in the past. This concept is known as precedent. The doctrine of stare decisis means to stand by things decided. Must courts always rely on precedent? Usually, yes. However, if a court finds that precedent violates the U.S. Constitution, it can overturn precedent. For example, Plessy v. Ferguson, in that case, the U.S. Supreme Court case in 1896, the court upheld a state law that required racial segregation on trains. This decision was later overturned by another Supreme Court decision in Brown v. Board of Education, which held there is a right to equal education under the Equal Protection Clause. Balancing precedent with unconstitutional law and societal change. Precedent and stare decisis is not absolute. Courts at times will overturn or abandon precedent in constitutional cases. More recently, in June of 2020, the U.S. Supreme Court struck down a state law, which law placed restrictions on physicians performing abortions. The decision was due in large part to precedent. You see, there had been a prior case decided in Texas based on a similar state law, which law was found to be unconstitutional. Justice Roberts, who was part of the majority decision in the 2020 case, indicated that while he disagreed with the result, his duty was to follow precedent. Will such precedent, the rights of women to seek abortions, be overturned in the future? We will have to wait and see how courts continue to rule. When it comes to constitutional law, most laws are presumed to be constitutional. This is the general rule. However, if a law potentially discriminates against a citizen on account of race or religion, there is no presumption of constitutionality, and that law is instead subject to strict scrutiny. For example, in 1967, in Loving v. Virginia, the U.S. Supreme Court applied strict scrutiny to strike down Virginia's law banning interracial marriage. Strict scrutiny is also applied to laws that potentially abridge fundamental rights, such as freedom of speech. How does one overturn a Supreme Court decision interpreting the Constitution? The court may overrule itself in a later case. One example is the landmark case, Brown v. Board of Education, which overruled Plessy v. Ferguson. Plessy v. Ferguson was an 1896 U.S. Supreme Court case in which the court upheld a state law that required racial segregation on trains. This decision was later overturned in 1954 by the U.S. Supreme Court in Brown v. Board of Education, based on the right to equal education under the Equal Protection Clause. Another way a Supreme Court decision is overturned is through constitutional amendment. The 19th Amendment, which gave women the right to vote, repealed an 1875 U.S. Supreme Court case. In order for an amendment to pass, a 2/3 majority of both houses of Congress, plus ratification by 3/4 of the states, is required. There have been attempts to overrule Supreme Court decisions through constitutional amendments. For example, there was an attempt to overrule Roe v. Wade, which protects a woman's right to choose to have an abortion. The amendment proposed stated, "The right to abortion is not secured by the Constitution." The amendment failed to pass. Another example is a proposed amendment regarding the power to prohibit burning of the U.S. flag, but this did not pass either. How are the courts kept in check? Our system is founded on checks and balances. The idea behind this theory is that each branch of government checks the other, so that no one branch becomes too powerful. Though our courts have a great deal of power in interpreting the law, they are kept in check by the executive branch. The President appoints all federal judges, subject to the consent of the Senate. Thus, the President and the Senate influence who make judicial decisions. Throughout certain administrations, this has had a great impact. For example, Richard Nixon appointed 4 justices: Warren Burger, Lewis Powell, Harry Blackmun, William Rehnquist, to the U.S. Supreme Court, and thereby made a significant impact on the Supreme Court and American constitutional law. Aside from the executive and judicial branches, the legislative branch is our third branch of government. Article 1, Section 1 of the U.S. Constitution states that all legislative powers shall be vested in a Congress. Congress has enumerated powers, or powers which are spelled out in the Constitution. Examples of enumerated powers include: Congress may collect taxes, borrow money, regulate commerce among the states, coin money, and more. Aside from the enumerated powers, Congress also has implied powers. These implied powers come from the U.S. Constitution's Necessary and Proper Clause. This is a general clause which permits Congress to make all laws which shall be necessary and proper for carrying into execution its enumerated powers. An example of Congress relying on their implied powers is when Congress passed Obamacare, requiring all Americans to get health insurance or pay a penalty, a tax. How did Congress have the power to make such a law? Even though Congress did not have the explicit right to make this law, according to the U.S. Supreme Court, Congress had the implied right to make the law under their power to tax. With regard to the executive branch, the Constitution provides that the executive power shall be vested in a President of the United States. The President has specific enumerated powers, such as the authority to appoint federal judges and U.S. ambassadors, veto legislation, serve as Commander-in-Chief of Armed Forces, and more. One controversial issue is understanding whether the president has only those powers enumerated in the Constitution or whether he has additional powers beyond those enumerated. For example, does the president have the power to make war? He is defined as the commander-in-chief, but does this include the power to make war without Congress? The modern trend is that Congress authorizes the use of force rather than actually declare war. As stated earlier, the legislative, executive, and judicial branches of government are separate, yet each branch checks powers of the others so that no branch has too much power. This system of checks and balances is used to keep the government from getting too powerful in any one branch. The president is the commander-in-chief of the Army and the Navy, but only Congress can declare war. Even though, as we just discussed, this is controversial. The president nominates judges. The president can veto congressional legislation. Congress approves presidential nominations, as well as ambassadors, Supreme Court judges, and more. Congress can pass laws over the president's veto. These are all examples of how our system of checks and balances work. Congress can impeach the president and remove him from office. The Senate confirms the president's nominations. The court can declare laws unconstitutional. Those are some additional examples of our checks and balances. Federalism refers to the division of power between the national government and the state and local governments. Remember that state policies cannot contravene policies of the national government due to the concept of national supremacy. The U.S. Constitution is the supreme law of the land. Article 6, paragraph 2 states, "This Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land, and the judges in every state shall be bound thereby." Treason is the only crime constitutionally defined. This crime has exclusive federal jurisdiction. Article 3, Section 3 defines it as levying war against the United States or adhering to its enemies or giving them aid and comfort. A conviction requires 2 witnesses or a confession in open court. You may recall the name Edward Snowden. Snowden worked for the CIA and NSA, and in 2013 leaked details of top-secret government surveillance programs to the press. He was charged with espionage and is seeking safe haven abroad. The question remains whether Edward Snowden committed treason, not just espionage. Treason is very difficult to prove, as even if one meets the requirements, 2 witnesses are required. Writ of habeas corpus. This is a constitutional protection. It provides that an individual cannot be held in unlawful custody. The government must bring a detainee to court and show cause for the person's detention. In the past, this has been a hot issue as suspected terrorists were held at Guantanamo Bay without formal charges or trial. Most of those prisoners have since been released. Ex post facto laws. This is a constitutional protection. Also, the government cannot make a new law or change a law and then retroactively apply it to a prior conduct, which when committed was legal. The government cannot increase a penalty after a crime has been committed. The Bill of Rights includes the first 10 amendments to the Constitution. They were adopted by the first Congress in 1789. They were ratified by the required 9 states in 1791. The Bill of Rights were adopted as a set of limitations on the federal government. It was later held that the Bill of Rights applied to the states. First Amendment freedoms include religion, speech, press, and association. As you may know from the news and controversial court cases, these rights can be quite controversial and none of them are absolute. For example, freedom of religion. The idea of separation of church and state is controversial as it relates to public education. Courts have stricken down laws that required students to say prayers in public schools. However, the Supreme Court has ruled that states that give tuition grants to children in private schools may also give aid to children in religious schools. With regard to freedom of speech, certain dangerous speech is not protected, like yelling fire in a crowded theater or bomb at an airport security checkpoint. Freedom of the press. This is also controversial when it comes to leaking classified information which threatens national security, as we talked about before with the case of Edward Snowden. Freedom of association. This right sometimes conflicts with government efforts to eliminate social discrimination. For example, in 2000, the U.S. Supreme Court held that the Boy Scouts of America had a constitutional right to prohibit openly gay men from serving as scout leaders. The Constitution protects the accused in that all persons accused of crimes have certain rights. The Fourth Amendment protects against unreasonable searches and seizures from the government. The Fifth Amendment protects against double jeopardy and self-incrimination. The Sixth Amendment ensures a defendant a speedy and public trial and the right to confront witnesses. The Eighth Amendment protects against excessive bail and cruel and unusual punishment. The 14th Amendment. The 14th Amendment states that no state shall deprive any person of life, liberty, or property without due process of law. This clause is known as the Due Process Clause. The Due Process Clause can be broken into two parts: procedural due process and substantive due process. Procedural due process requires a fair notice and a fair hearing before depriving a person of life, liberty, or property. Substantive due process requires that the government policies cannot be irrational, unfair, unreasonable, or unjust. The Equal Protection Clause provides that no state shall deny to any person within its jurisdiction the equal protection of the laws. This clause prohibits states from denying any person or class of people the same protection and rights that the law extends to other similarly situated persons or classes of people. This is controversial when it comes to affirmative action, which are efforts to assist minorities in employment or education. Courts have maintained support for the concept, but limited circumstances in which it approves. The U.S. Supreme Court has upheld the University of Texas's affirmative action program as constitutional. The justification there is to create a diverse student body. And with that, we conclude the podcast for constitutional law.